Welcome to the London Policing Seminar Series, which are run jointly between the UCL and CCPR, so the Canterbury Centre for Policing Research. Your chair, who is Dr. Martin O'Neill, who's sitting next to me, was meant to be taking you through the series today. Unfortunately, he has lost his voice. So my name is Dr. Katarina Mozova, and I am Martin's voice for today. So we will be sharing the chairing position for this one. Understandably, in a way of introduction, domestic abuse, I think all of you who have signed up for this are very well aware is a problem that we have experienced in this country and internationally for as long as we have any evidence of these types of crimes happening. It's definitely an issue which has been discussed more and more in recent years, which is understandably a good thing. However, on the flip side of things, it does seem that the more it's discussed, the more problems are uncovered, and the more we are struggling in effectively evaluate whether what we're doing is the right thing to be doing, whether we need to change things, and where we really need to move on from the situation we're in. I am sure that most of you would have also read the report which came out recently from Baroness Casey, which I think further just highlighted, even though that wasn't perhaps the core point of the report, that we need to do much more when it comes to domestic abuse from all perspectives. So that's from prevention, investigation, prosecution, etc. So I think that this series, this part of seminar series today is very timely, it's very important, and we have three wonderful speakers. So we have with us Lucy Trafford, Professor Susan Edwards, and Andy Myhill as well. I will give you more of an introduction to each of the speakers as we go to each of them. The first one who is going to talk to you is Lucy Trafford. So she is your first speaker, and Lucy studied law as an undergraduate and Maurice Hyman Scholar at Christchurch, is a Maurice Hyman Scholar at Christchurch College in the University of Oxford. She then completed a Master's of Philosophy in Criminological Research at St. John's College at the University of Cambridge, before returning to Oxford to commence her doctoral philosophy in criminology at Balliol College. Lucy's research is funded by the Oxford Law Faculty and the Centre for Criminology, and she is also a Leather Sellers Scholar. She's researching how the dynamics of domestic abuse influence police decision-making and approaches to intimate partner violence, and hopes that this work will have a beneficial impact on policies and legislation which are currently being revised. She's conducting empirical research using a mixed methods approach to analyze quantitative and qualitative data collected and to conduct interviews with individuals who play a key role in the criminal justice system. So what she will talk to you today is all about risk relating to domestic abuse incidents. And I think I'm going to pass on to you now, Lucy. Oh, you're still muted, Lucy.
Thank you very much for that kind introduction. So I'll just share my screen now. So let me know as long as you can see this. Sorry, 1 second. Hopefully this is working.
Yeah, I can see it.
Yeah, brilliant. Okay, so excellent. So hopefully you can now all see the presentation.
Yes.
Wonderful. Okay, so in that case, I'll now get started. So obviously, as you said, my name is Lucy Trafford, and I'll be presenting part of my PhD research. So this looks at how police understand and identify and respond to risk in incidents of domestic violence. It should be noted what I'm presenting today is preliminary. So I've analysed case files that I'll talk to you about and a few interviews, but I haven't completed all of the research yet. So I'll just change slide, there we go. Okay, so this presentation seeks to understand how officers identify and determine risk by analysing 34 cases of intimate partner violence incidents. These were all reported to a Southeastern police force between February and July 2019. It's part of a wider project, as you said, which includes quantitative analysis of 26,091 incidents. The aim of that is to understand the context of what types of cases are being reported to the police. And in order to contextualize these findings, I'm then using case files and interviews. The case files selected that I'm going to talk about today were randomly selected using a code on MATLAB, which was presented to analyze a representative sample of the 26,000 incidents that were coming through. So what we're really trying to look at here today is how officers determine what risk is. And although the original quantitative analysis did look at data from COVID, this will only be looking at data from 2019, as it was decided that more generalizable information would be available that way, especially as the force that I was working with, as well as several other forces, implemented new policies during lockdown to determine risk and what incidents to deploy people to. So I also carried out interviews with officers. These were all conducted remotely and were semi-structured interviews with 11 officers across 6 different roles. And officers were communicated with and gained for this survey by, for this interview, by answering a survey which was emailed around to their department. So looking at risk, in England and Wales, risk levels are applied to domestic abuse incidents to determine the severity of violence experienced by victims and also the risk of future abuse. So this is then to determine what risk levels to apply to them, which range through standard, medium and high. And this enables prioritization of limited police resources by determining what kind of response they need for victims, what kind of criminal justice response is necessary as well. In order to make these decisions, the police use dash forms. So they record 27 answers from victims, which cover the impact of abuse on them, their relationship, and the suspect's behaviour. These questions, alongside police observations, are relied on to determine the risk, and then they're assigned either at the scene or immediately following. So as Myhill, Hoyle, and Johnson have also found, there is a difference in how officers understand the dash forms. They may see different reasons for the use. They might administer them differently. Some of them will work through the questions continuously. Others will fit them into discussions with people. And also they might fill out the form differently. So some people might say, just sort of tick X areas as yes or no, while others might put more information in. And the level of that information also depends on what officers see as important. So this means that it's really important to understand how officers determine risk levels, as obviously there is an inconsistency in this approach, and it will also determine these later criminal justice responses and also the support for victims. So this research focuses primarily on the free text, which is completed by officers within the dash form. Most notably, officers' own observations and the evaluation of risk are focused on. So the officer of evaluation of risk is where officers will explain what risk level they're applying and why they think that's relevant, whereas their observations will explain what happened during the incident, the surrounding context, and any other factors that they think are relevant to determining risk. So these sections are focused on primarily as they will provide the best representation of officers' perceptions, their reasons for determining risk, and also their own voice. So factors affecting risk. Officers cited 4 main factors as influencing their determination of risk. These were recorded police history, proximity between the parties, the suspect unpredictability, and also the impact on victims. So I'll just take you through all 4 of these briefly, and also show some quotes that really highlight the points I'm making in these cases. So the first factor, which was highly influential, was previous history. And this previous history was used to provide contextual information. So it ensured that officers considered previously recorded details about the abuse the victim had suffered, changes in the relationship, and it also supplemented information provided by the victims. So for instance, in case 3, the officer reviewed prior dash forms thoroughly and discussed discrepancies between the victim's previous and current answers. So this was to determine whether changes were indicated that the victim was suffering less harm, whether there was a change in information because of the fact that the victim had missed out some of that information or misremembered, or more importantly, whether this change occurred because of the fact that the victim was being more extremely controlled by the abuser. So in this case, the officer stated, "There's quite a contrast from the previous 2 domestics, from the previous answer provided as yes to the ones today provided no. They are all control-based, and therefore there is a concern that this could be a result of controlling behaviour. Although there's been no clear abuse in this incident, there is some history between the pair, which shows there's potential of harm." Now, this is a really good example of officers filling out the dash form carefully and using previous history in a really helpful way. This wasn't always the case amongst them, but I thought I would highlight this one to show that there is some really good work being conducted. And there's also a quote at the bottom from another interview with an officer, where they explained about how they find it helpful having this information from previous incidents, either on dash forms or they've personally gathered from going to previous cases, when they're coming up against victims who might sort of not try to basically cover up effectively what's happened or try and downplay the incidents, possibly because they're fearful of criminal justice intervention. And then also relying on this previous police instance proved really helpful for officers where victims and suspects would not engage. So for quite a few cases, it was stated that the victim or suspect would not answer the questions or was not willing to answer the questions, in which case officers then use previous risk assessments to determine what level of risk should be provided, because they still had to complete a dash form, they still have to ascribe a level of risk, and obviously this can be hard when they don't have any information. Although, as one officer noted, this information is sort of supplementary and it can't be used to represent as an equivalent to information they would have otherwise gathered. So this officer in case 12 explained, "Please be aware that I have not been able to contact the aggrieved party, so this has been created using my own professional knowledge and research. I cannot say the aggrieved party would answer in the way I have assumed. Equally, I cannot say for certain that the answers are given an accurate description of her current situation." Now, while the frequency of IPV reports being used is helpful to build up this history and this understanding of whether incidents are escalating, there was also a problem with officers using this frequency as a marker for how often victims experienced abuse in cases where there was infrequent reports. So for example, there's a few different quotes I've got here, but I think the most notable one is from case 1, where it was stated that this is the first call in nearly a year from these two, so it will be graded low. Now, this is problematic as IPV is highly underreported crime. Victims are unlikely to report to the police in many instances, if at all. And when it does come to the police, it doesn't mean that it's going to be every incident or even the most serious incidents. Victims have been found to report when they are most fearful. And actually quite a few of these cases only came where they were high risk, only came to the officer's attention because they were reported by neighbours. And for example, Refuge have found that less than 24% of domestic abuse crimes are reported to the police. So this demonstrates that a lack of prior knowledge really should not influence the police decision-making. Instead, where there are prior reports and it goes over a long history, they should look at this as a time frame for when the abuse has been experienced. There were also, again, some really good officers recognising this. So one officer recognised the importance of looking beyond police reports and explained in interviews, actually, just because we've graded the last incident low doesn't mean to say that the thing that happened last week that we don't know about wasn't high. And actually, we're perhaps missing opportunities there. So this shows that prior information can be really helpful for officers in determining the appropriate response, but it's also important to ensure that information is used in the appropriate manner and that is not used as a proxy for unattained or unattainable information. The next factor that I found to influence police decision-making was proximity between the victims and suspects, and specifically whether they cohabited. So, for example, in case 23, officers were fearful that situations would be more likely to flare up and that there might be more violence due to contextual stresses with the parties living together. So, for example, the officer stated, "This is the first time disclosed assault and confirmed by victim no previous assaults, but they lived together." It was also stated, medium risk on risk assessment as they lived together and the money worries and other stress that led to this argument and assault will still exist. So again, this shows the focus that officers are placing on the possible contextual factors and stresses that might be created by parties living together. And this understanding seems to reflect Johnson's view of situational couple violence as possibly being triggered by situational stresses. However, this overlooks the clear issue with perpetrators being able to harm their victims and make victims feel unsafe in their homes without even entering it. So, for example, in case 27, it was stated that the victim did not live together, yet the victim received messages from the suspect referring to their location, stating they were outside the victim's house, stating they were outside the victim's school, and even sleeping outside the victim's house when they were not allowed in. So it's notable, if you look at the bottom of the quotes on 27 as well, it says that the safety of the victim's house and the inability of the suspect to enter was emphasised. And this was obviously despite the fact that the suspect later broke into the victim's house, which undermines this supposed security and this view that actually proximity would act as a buffer. So for example, they said here, the victim lives in a flat with locked door and entrance has to be given from resident. Suspect has no key for the address. Although later on in the report, they then explained, she reports leaving the address locked and secure, except for perhaps a window on the latch. When she returns, she noticed the doors are unlocked and notices her laptop and paperwork relating to mediation with the suspect is missing. Additionally, in case 28, where the level of risk had escalated massively in just 3 months, the officer's rationale mentioned that the suspect does live approx 1 hour from her home address, and given this, I believe she is medium risk. So this again indicates that this lack of cohabitation and this distance between the victims and suspects was seen to act as a protective factor or a buffer from future harm, therefore reducing the risk to the victim of abuse. Now, in this case, this occurred despite the fact that the suspect had sent multiple items to the victim's house. They frequently had been seen around their house, and they also had caused the victim to actually move out of her home address because she was so worried about the suspect constantly turning up. So for example, in this case, they stated, victim came to us today explaining she had been living away from her home address and just been overwhelmed with the other stalking, and has come to us with all this new information about this new stalking. So again, this also shows a bit of a misunderstanding here about this idea that stalking can happen in chunks, although that's something that hasn't really been focused on here. So the stalking by suspect involved emails, texts, letters at address, parcels being delivered, plus photos of places near to her address, plus threats to burn her house down, and her children seeing the suspect's car near to the address. So again, this presence, despite the distance and increased effort, might actually mean that the stalking that the victim was experiencing should be higher risk, especially because the suspect in this case is actually going to more extensive lengths to remind their victim of them and to make them appear omnipresent. So if anything, this idea of distance should really have acted as another reason to increase the level of risk that was seen here. Another issue with police responding to instances where victims did not cohabit was this idea that a lack of communication would mean that there would be a lack of proximity, and cohabitation would mean there would be a lack of future communication between the suspects. So for example, in case 5, it was stated, neither party are in contact with one another and do not live together. So any risk is severely reduced. However, this overlooks the need for victims and suspects to communicate in instances where they are both sort of have child contact communication, which is arranged between them and might be informally facilitated by the couple. So although officers suggested, so I was going to say, although the officers actually suggested finding alternative methods of arrangements in case 27, it was clear from this case that the suspect would actually only engage with the victim and enable the victim to collect the child. So even when you've got these third parties being used to sort of remove any contact between the suspect and the victim, suspects will often manipulate these situations of child contact to ensure that communication remains and control remains over the suspect. Again, recognizing that this idea of proximity shouldn't be seen as a buffer for victims not living together. In case 11, the officers recommended stopping communication between the victim and suspect and finding alternative means of facilitating contact, despite the fact that this was unlikely because they already had an ongoing court case through which this contact had been organised, and also considering the fact that there was just 4 days between the next court date. So again, this shows that I guess officers don't really see another option apart from suggesting this lack of contact, rather than considering how this contact could maybe be facilitated in a safer way, or we need to put more thought into how we could make sure that communication between parties who have children once they're separated is safe. So for example, in case 5, we see here that actually both the parties had their contact regulated by social services. So previously, the victim had been sprayed in the face with bleach by the suspect, and this had led to social services being involved in order to establish a more regulated agreement. However, even in this case, this official agreement broke down because the suspect had changed their minds about child contact and when they would be available. And this obviously led to both the parties needing to communicate. And this indicates that actually, even between couples where there's regulated contact, communication might be necessary at some points. It's also worth noting that in this case, the history of assaults, there was quite a history of assaults at handover. They all seem to occur when the children were handed over. And again, this demonstrates that actually, even when you've got regulated contact, there can be instances, even if it's just the handover itself, which can be dangerous. So it's very important to not, again, see this as lower risk, just because they think that there's going to be less contact between them. So another thing that we can see as causing impact is the officer's perception of the impact on victims. Now, this is quite important to understand because obviously it's an observational impact that officers are having when they go in, as well as communication with the victims. And they cited this as influential for understanding the sort of severity of harm caused to victims. So obviously injuries were primarily focused on and referenced to as evidence of harm, but officers did also look beyond these physical injuries to look at other physical impacts on victims. And the two main forms of impact considered beyond injuries were upset and fear. Now, as you can see from these quotes, often these were recorded by officers' observations of victims crying, victims shaking, or victims appearing scared. And this reiterates both Hoyle and Myhill's findings as well. However, it is imperative for officers in these instances to identify fear and upset through alternative means other than looking at the physical impact, or possibly even by listening to what victims might say, as there may be instances of fear that aren't necessarily communicated directly. For example, Kelly has found that victims might minimize the abuse that they've suffered, or victims might not recognize the abuse that they're suffering either. So this means that it's very important for officers to overlook these instances where they can see the clear harm and to understand that it's subjective and that there may be different ways in which victims communicate this. So for example, lifestyle changes should be perceived as indicative of victim fear and upset. So we can see this in several instances where victims took precautions to protect themselves from the suspect, as in case 15, when the victim said that they attended a doctor's appointment in this case, and they got a friend to follow behind in case anything happened. You can also see that there was changes in lifestyles with victims avoiding encountering the suspect by not going out. So one victim explains that I won't go out and about. If he doesn't have friends, he would literally sit in his flat, looking out the window, worrying, while another victim said, in short, my life is intolerable. I look over my shoulder all the time. So again, this shows the inherent difficulty with officers focusing on these visible signs, because it's really this importance in change of their experience and how they live their life and the impact on their quality of life as well that should be considered. Another reason for not looking just at these physical impacts, but also looking beyond what victims say and trying to contextualize how they have presented themselves, how they've presented changes in life to understand the impact on them, is because of the difference that might be seen in gender. So for example, Hamill explains that males are less likely to show fear or upset because this can be seen as a sign of weakness and undermining their masculinity. So for example, in this case, an officer shared during interviews doubt that a victim had been protected and treated appropriately on the basis that they were not visibly fearful or upset during interactions on body-worn video, despite the victim previously admonishing themselves and crying and trying to appear unfazed in front of that particular officer. So the officer explained here, the male I spoke to last week in a same-sex relationship kept crying and then immediately stopping himself and going, so embarrassing that I keep crying in front of you. But because he wasn't upset on the body worn, they felt that actually you couldn't prove that he was emotionally distressed in the moment and that this account wasn't believable. He was very controlled when he was physically trying to control his emotions because he was embarrassed about being upset in front of me. And he may very well have done that with those officers. So again, this really shows the inherent dangers with just looking at how victims are presenting themselves rather than beyond what you can see and looking more at like what they're saying and how they're experiencing these changes. So the final factor that I wanted to talk about is unpredictability of suspects' behaviour. And this also seemed important for officers determining the level of risk, because unpredictability makes it very difficult for both the victims and the police to predict likely actions from the suspects and to determine whether and how this abuse might escalate. So this uncertainty makes their behaviour inherently riskier, and it is also clear from certain steps taken which might appear unusual to try and harm their victims or communicate with their victims. So for example, Monckton Smith has found that this type of behaviour is especially evident where suspects are trying to reinforce their control, and especially in cases of separation. So for example, one frequent form of unpredictable behaviour, as I said, was the suspect unexpectedly turning up at a victim's house, or that of friends and family, and especially at unusual hours. This behaviour was again further exacerbated when erratic actions were taken, when a victim refused to engage with the suspect, undermining their previous control. So for example, from case files, this included threatening to set fire to the victim's house, with one suspect saying, "If I can't come in the house, then I'll burn the house down." Another suspect sent pictures of them making a noose and attempting to hang themselves outside the victim's house, with the victim explaining, he then sent a photo of himself pretending to tie a scarf loosely around his neck at the bulkhead of his van to try and cause a reaction, while another suspect slept outside the victim's door all night. As well as making it hard to predict suspects' future actions and the risk of harm posed to their victims, these behaviours indicate the lengths that these suspects are willing to go to communicate with and enforce control over their victims, making it harder to know whether they'll escalate. This is particularly clear from this one case on the side here, which was a very extreme case, where the victim had tried to detach themselves, and in response, the suspect had faked a pregnancy, faked a termination, and faked a funeral as well. This also indicates again the difficulty that victims have with eliminating contact with those suspects when they have children or potentially have children, because the victim in this case stated, "The only reason that I've allowed future communication is because of the issue of realised over the possibility that she was pregnant with my child." So overall, it appears that officers' determination of risk is informed by reliance on previous dash forms, although these can be used positively to review victims' questions and changes in escalation of suspects' behaviour over time. They are also relied on problematically to equate the frequency of incidents reported with the frequency of abuse suffered. Escalation in unpredictability of suspects is also a clear indicator of risk, particularly where suspects' reactions to victims not complying with their wishes are especially erratic. And unsurprisingly, this tends to occur for those which are not living together. So while proximity itself appears to be a relevant factor, despite victims are obviously still controlled in relationships where they're not living together. And this is especially clear for some of those victims' quotes we saw earlier, where they were talking about how they feel they are being constantly watched, or as if their partner is their abuser, is omnipresent and can see them at any points. So finally, this victim impact further influences officers' determination of risk, although it does appear harder for officers to recognise these changes in behaviour as indicative of fear or upset, when they don't tend to include these physical responses such as crying and shaking. And unfortunately, this focus on physical impacts does mean that officers tend to focus more on female victims' responses, and identify fear and upset in those cases rather than in cases involving male victims. So that's my presentation. Thank you very much for all of you for listening. If you have any questions, feel free to email me, or obviously I'll answer in the chat at the end. So thank you.
Right. Thank you so much, Lucy. That was really interesting. I think we all really enjoyed seeing the actual quotes as well. I think it really brought some of the issues to light and kind of the thinking patterns of the different actors within domestic abuse. So thank you. Yes, feel free to start asking questions in the chat. So Lucy does have to go quite soon. She has a previous engagement. So we will. Oh, Lucy.
Oh yeah, I was going to say. So I've actually managed to move that a little bit later, so I can actually stay a little bit longer if there are questions at the end.
Oh,
but I need
excellent. Yeah, if that's fine, then that's perfect. Yeah. So we'll quickly reorganize. So we will leave questions to the end. If you do have them now, feel free to start popping them into the chat, and we will obviously have a look through them and ask at the end. And this is our preferred way of doing things, because even the question that is already on there, I think that, you know, it can be answered by all three of you really with different opinions. So please, all of our lovely participants, do start asking questions, pop them into the chat. We will get to them towards the end of today's session. Yes, so thank you again, Lucy. So our next speaker is Dr. Andy Myhill. He is an evidence and evaluation advisor at the UK College of Policing. He has undertaken research on policing for nearly 20 years, first at the Home Office and subsequently at the National Policing Improvement Agency and the college as well. He has also worked on the crime survey for England and Wales, and he is a very widely published author across different spheres, really. So that would include academic papers, government reports, and it's on a number of topics: public attitudes to the police, community engagement, procedural justice, and very understandably also on domestic abuse. That's why we're so glad that he can be here with us today. And the presentation that he will be taking you through is specifically focused on what counts as success in police response to domestic abuse. So off to you, Andy. Thank you.
That's great, thank you. My internet connection's actually been a bit glitchy through the first presentation, so you'll have to let me know whether it's affecting.
Okay.
I'll try and share the screen now.
Yes, I can see the PowerPoint. Perfect.
Okay, so we're going to be looking at what counts as success in evaluating police use, and specifically looking at the construction of data, and the issue of how to with police data. We're going to be drawing on recently published studies where we presented ethnographic data, so lots of first response officers and some DA investigators. And I'm also going to an argument from forthcoming paper with Professor Liz Kelly, which is actually in production, so it should be out pretty soon, I think. That discusses this issue of police data and how it contrasts with what we call survivor-based data and how harm is being using police data. So just in terms of a bit of context, there's been a massive increase in the profile of domestic abuse and women and girls in the last decade, I think. There was a big thematic inspection of domestic abuse, so the police inspection 14 that spawned kind of a programme of work for us, really, which has continued since 2015. You had enactment of the groundbreaking legislation controlling coercive behaviour, more legislation in 2021 Act, which Susan's going to be talking about, and a lot of activity generally in 2021. I think uncoincidental to the Sarah Everard case, an appointment of a VORG national lead for policing and a VORG task force and delivery plan, the initiation of Operation Sateria Bluestone, which I've also been working on, investigation of rape. And very significantly, I think this year VORG was at strategic policing requirement, which puts it on a par with counter-terrorism. Increased focus has led to a lot of activity generally, to need to kind of assess police performance in this area and try and assess the outcomes of stuff that's being implemented is actually making any difference. Before getting to some of the specifics, I just wanted to talk about the way data is constructed in this area. So social science data is constructed, and it's most often in relation to constructed through dialogue with victim survivors. I think we need to consider the differences in how what we term survivor-based data and police data is constructed. So survivor-based data, there's a very rich tradition of feminist research in relation to this topic that's generally collected by people who are understanding domestic abuse. It's collected empathetically in a mutual trust and collaboration with survivors. It's collected most often at a time when they've had time to process their experiences and a comfortable disclosing. So it's for the purpose of kind of fully understanding their experiences and reflecting lived experience in their own language. And there's quite a contrast, I think, with the way that police data is. So it's collected for a much narrower purpose, primarily for recording and investigating crime. Our research suggests it's collected by people who often have no specialist knowledge or understanding of domestic abuse. So sort of knowledge and understanding amongst first response officers in particular is very, it's frequently collected at a point of crisis, where the victim naming the abuse or maybe choosing to minimise the abuse. Again, our research may often be collected in a context of scepticism about victims' accounts. And then it's reduced to high-level categories that are imposed by the criminal justice. So we argue that the nature of this construction of police data does pose if data is used to evaluate interventions. And how success is generally judged in relation to interventions. Often it is police data that's used. Why is that? I think it's probably because it's easiest to access. Longitudinal follow-up with victims, whether that be by surveys or preferably in interviews, is resource intensive and it's logistically difficult. Police is easier if it's just there on systems to be drawn off. And there's various kind of police data that are used to represent recidivism or so if we use convictions, further conviction charges, we can probably look quite successful because there's a relatively smaller proportion of reach charge or conviction. And even further arrest is difficult. Always meet a necessity to arrest, and forces are increasingly using voluntary instead of arrest. So the most complete measure, or the most widespread measure, I guess, is any recontact with the police. And that is problematic. Obviously, it's dependent on reporting. And it's kind of almost not worth saying, but it is. There's a massive assumption that no further contact, assistance in abuse. But really, actually, we have no idea what happens in those cases. You report it to the police. It might be that the abuse desists, but it equally might be that that's an attempt to stop people from reporting further. It's also recording, and we know from our research and other people's research that there are issues with crime recording, and HMIC inspections suggest not all crime is recorded, and also not all domestic abuse crimes are flagged, as in forces are supposed to put a DA flag. Makes it easier then to identify those on the system, but there is some degree of error in applying that flag as well. It's also dependent on accurate recording, and we also know that there is an over-focus on recording physical assaults. To that in a second. And also there's the kind of fundamental question of how do we interpret recontact with the police? Because again, it's generally assumed that further contact means abuse is continued and therefore that's a bad outcome. But actually, if you're evaluating some protective order, further contact might mean that victims are engaging and are more confident to use that mechanism to try and protect themselves. So further contact is necessarily a bad thing. And if we contrast that with what success looks like for victim survivors, again, research that has looked at this issue. So Nicole Westmoreland and Liz Kelly, as part of their Project Mirabelle evaluation of perpetrator programs, did in-depth work with survivors to ask what they would regard as successful outcomes of a perpetrator program. And these factors are kind of in order of salience or order of how strongly that. And what you can see is that physical violence or cessation of physical violence is quite far down the list. Much more salient to people were respectful communication and not being in their life, having a bit more space for action, not being isolated. So a lot of the and actually there's loads of qualitative research in these controlling and coercive relationships is cumulative, and the profile offered by victims are extremely complex. And that has implications, I think, for this understanding of how survivors view harm is important. As researchers are increasingly applying severity scores and crime index data to domestic abuse and war. There are two main systems, the Cambridge Crime Harm Index and ONS crime severity scores. They apply sentencing data to crime codes to try and make it go beyond just the basic crime code. They do it slightly differently. The Cambridge sentence start points in sentencing guidance, and the ONS scores is passed down for specific crimes. There's a useful paper by Matt Ashby, the pros and cons of each of those systems. But we actually argue that applying data at all is inherently problematic in relation to domestic abuse. And we argue that it's problematic for two main reasons. So first, we think that war crimes are often undervalued. So the chart shows some examples of crimes, VORG and non-VORG, with Cambridge Harm Index score. So you can see actually that controlling and coercive up-weighted at some point in the system, because the starting sentencing for that offence is a medium level community order. So it was up-weighted to be level, putting in fear of violence. Actually, both of those offences, conduct offences, lag far behind a single incident of robbery. So when underestimate at all the impact and potential harm of a robbery incident, and I don't necessarily consider that it would be, or indeed several times more harmful than a course of conduct offence which traverses time and space, and in the worst cases involves people in their own homes for weeks, months, or even years. You've also got the breach of protective orders. So if you can notice, breach of a non-molestation order scores very on the scale because of on the Cambridge scale, at least because of the low start. What will often happen in these cases is that rather than crime, well, actually the original crime might not be coercive control or stalking, but even in those cases, breach of an order, it won't necessarily be crimed again as another crime of coercive. It will be crimed as breach of a protective order. So in harm index, there's been a massive reduction in harm, whereas actually the victim would no doubt continuation of the same course of conduct. And the second reason is to do with the process of crime recording itself, as I mentioned before. So HMIC inspections have continuously shown that a reasonable proportion of crime isn't recorded, but they've also shown as against the person and sexual crimes are disproportionately poorly recorded. But crimes, so coercive control and stalking, are especially under-recorded as well. So Charlotte Barlow led some work looking at case file analysis and suggested that 9 out of 10 crimes of ABH assault have controlling and coercive behaviour evidence, so potentially could have been recorded as a cause of. And our research, and certainly our research, has suggested there the lack of understanding of those offences among first response officers. But our research also showed that even where you got officers who did have a pretty good understanding of course of conduct and coercive control, they were still preferring to record, partly because I think that's just what they're used to recording, but also there appeared an imagined very high evidential threshold for recording course of conduct offences. So the result of that is that a lot of the abuse that would fit the kind of victims' perceptions of harm a lot more, so course of conduct, maybe an ABH type level on a harm index scale, or actually it's not recorded, it's left as a non-crime incident. And I've never personally bought the argument that thousands of people call the police every year just to report that they've had a verbal argument with their partner, in the absence of any underlying ongoing abusive context. So I thought to finish, a case example might be helpful to illustrate this. This is an actual case example from an incident I observed. The victim risk identification into the officers taking a formal witness statement. And this in this type of moving vehicle to escape her ex-partner, as he turned up somewhere she was unannounced, and she got into his car to avoid him making a scene. She was speaking to a male friend who he proceeded to interrogate her about that and use sexually derogatory language and punched her at least twice in the vehicle. During the risk assessment, she disclosed controlling and stalking type behaviours. She also disclosed impact on daily activities, including being prevented from seeing family. During the time that they were taking the statement, she actually received multiple abusive and threatening texts from the suspect. But the crimes that were recorded in relation to that was an ABH assault and a secondary offence of malicious communications. As we had access to the case files for the next few weeks and months, there were subsequent non-recorded, which, as I said before, to the victim, that will no doubt have been a continuation of the previous abusive behaviour, but in harm index terms, it would have been a 100% reduction in harm. So to conclude, we suggest crime codes are a way of representing harm, and I don't actually think adding sentencing improves it that much. In practice, I think applying harm indexes to domestic abuse and VAW kind of minimises and misrepresents and actually indeed excludes altogether a significant proportion of the harm that victim survivors say is important to them. I think there is a risk then that police data and harm index data can the perceived success of interventions. I think it will also exaggerate the harm that people suggest is caused by a power few prolific offenders. I think there are a lot of harm, but this probably will exaggerate it because it just squeezes out a lot of the harm. One of the key justifications for using harm is that they are easy to operationalize. But I just think if the measurement system misrepresents what it's trying to measure, it's not an adequate justification that it's easy to implement. So I think there's a need to look at measuring harm in a more way. There's actually quite a lot of data that exists on police systems. There is command and control logs that detail the original call to the police. There's body-worn video taken by first responders. There's risk assessments, there's formal witness statements, there's investigation logs. A lot of that potentially, and I would just include a plug for opportunity that we have the chance to host at the college, which I'm hoping we'll be able to look into this and work, examine how feasible it is to utilise some of this data, an improved measurement framework for harm. I think it's also important to think about non-CJS measures as well. There's a recent paper by Romney about this in relation to rape specifically, but I think you can extend that certainly to domestic abuse. There's a lot of work goes on by officers in relation to safeguarding and referrals, procedural justice outcomes that we talked about earlier, the victims, about space for action. That data, I acknowledge, will be harder to operationalise, but I do think we need to ask the fundamental question: whose conception of harm and success are we interested in? Police or victim survivors? And I personally think it has to be the latter.
Excellent. Thank you very much, Andy. That was a really interesting presentation. And I think that you've actually left us with a lot of very interesting questions right at the end there. And I also think that the Wi-Fi just about allowed us to really be able to take the presentation in. So that's all great. So thank you very much for that. As with Lucy, please do start asking questions in the chat. We do already have some nice questions for Lucy for when we're done with the presentation. So please start asking questions for Andy as well. And now we're going to move on to our last speaker for today, who is Professor Susan Edwards. Now, Susan is an emeritus professor at the University of Buckingham. She's a barrister. She's a very well-known writer. She's a campaigner. She's a broadcaster on feminist issues. And at the moment, she lectures in family law, sex, gender, and minorities in a legal process, criminology, criminal justice, and legal skills and procedure, and also tutors in constitutional and administrative law. So quite a wide scope of areas there. She is also the co-director of the Center for Multicultural Studies in Law. As a very relevant note as well, she's currently the editor of a forthcoming book, which I'm sure all of you will be very, very interested in, together with David Malone and Gillian Jones, which is the Blackstone's Guide to Domestic Abuse Act 2021, as part of the Blackstone's Guide series, which is out hopefully soon, or is kind of just about out, should be just about now, probably around May time. So pre-orders can be going in. So I'm going to let Susan start now, and Susan is going to talk to us about part of what is mentioned in this book. So it is the Domestic Abuse Act 2021, particularly sections 1 and 70 and 71. So over to you, Susan. Thank you.
Okay, Dr. Katerina, thank you very much for the introduction. And it was very interesting to hear what Lucy and Andy had to say. And I hope that what I'll say will in some way build on that rather granular picture that we've had, that very important picture, which actually goes to the heart of policing practice. So to just say as well, I want to just note my thanks to Martin, who has been absolutely incredible in the amount of work that he's put into this particular edited book on the Domestic Abuse Act. And you're quite right, Katerina, it'll probably be out in May, if not before, but it's already up on the web to have a look at. So just moving into the Domestic Abuse Act, I've got section 1 up there. Can we go on to the next screen? But I'm actually going to have a look at the two areas, section 70 and section 71. And as I was listening to Lucy, she was talking about risk. I was listening to Andy, he was talking about harm. And actually, one of the important and key areas, I think, for police at the moment is how to identify non-fatal strangulation. That's a problem as well for the courts. We're feeling our way with it. But I think there is some way in which I'll be building on what we've heard earlier. So why bother about strangulation? I should say we're talking about non-fatal strangulation, which is part of the Act. That's section 70. I'll come on to the legal detail later if you're not familiar with it. But that deals with strangulation and suffocation, or I should say, or suffocation. We've got to be very specific with the language. There's been criticism about whether this will embrace everything that we need to criminalize. Why is it important? Well, let's look at the prognosis, if you like. Let's look at the relationship between method of killing in intimate partner violence and death. I was fortunate enough over the years, sorry I'm speaking quickly, but I know we want to get on to the questions. I was fortunate enough way back in the 80s when I started looking at domestic violence to have access to Home Office statistics, which didn't break down the relationship of victim to suspect in the intimate partner situation, or actually necessarily with the method. That's the point, with the method. But they did do computer runs, and this is what came out. So I've had a number of data sets, but if we look at the most recent data set, which is data set 4 from 2011 to 2019, we find that 23% of deaths of female intimate partners from male intimate partners in a binary heterosexual relationship are 23%. So we've got every reason to be very concerned about non-fatal strangulation, which actually occurs in many of these cases as, if you like, a precursor to the fatality and lethality of this. So moving on to the next slide, please. So there you have it. You have the statistics on the importance. Next slide, please, Hannah, who's doing a great job. Okay, Hannah. So, I mean, my work's been looking at the statistics, and, we know that there are, there are dumb lies in statistics, but I think the dead who cannot speak, a dead body is pretty much hard evidence, and harder evidence than statistics, shall we say, on the living, because it depends, as we know, on reporting. I know some of you are going to be thinking, aha, but, well, let's just look at one or two of the cases in the past that actually has prompted some concern. Many of you won't know of the Niall Duncan MacDonald, but please, it's a Scottish case. If you've got time, please have a look at it. It's an absolutely horrendous case, and I shall spare you the detail. We know, I think, a little bit more on the Coutts case, 2005, and that was a case that involved a ligature we could say it wasn't a partner, it was the friend of Graham Coutts's partner. And they had just met on that occasion. What is starting to creep into some of this narrative, which I'm going to talk about a little bit later, is the attempt, of course, in cases where a defendant is charged with murder, to disavow intention by bringing a whole host of other factors in. You know, obviously, you know, it was accident, or we were in a loving relationship. And of course, she consented, which I'm going to lead on to a little bit later. I put up the Bailey case there, and you can see that that creeping narrative. He claims in the course of consensual rough sex, don't like the word myself, don't know what else we should call it, but it kind of gives a veneer of almost acceptability through the lens, of course, of the perpetrator. And we'll get on to how that's actually used by some perpetrators. So Bailey is another important case. Should we just move on now? Thank you, Hannah. Now to the statute. That, of course, is the lovely Nigella Lawson, and that is Charles Saatchi. And this was printed in one of the tabloid press. There's a reference to it, of course, not surprising, it was the Daily Mail, but it was in a case not to do with violence, to do with some employment matter, to do with the those who were employed by Nigella Lawson. And he says, I wasn't strangling her, I was holding her head by the neck to make her focus. And I think the kind of narratives that perhaps you're going to hear or you're hearing from men when women have alleged non-fatal strangulation fall into that kind of category. I wasn't trying to do anything, I was just trying to get you to focus back to our discussion earlier on coercive and controlling conduct. So let's look at the sections. Some of you, I mean, will have to be dealing with this because here we're talking about those people who've survived. And what we see from the statistics, as I know Andy and Lucy will back up, and of course Martin, is that there's an increasing apparent prevalence of strangulation. All I can say from my own research, it's because we are now talking about it, that women, largely women, will actually report, he tried to suffocate me, strangle me, grab my neck, etc. The fact that there's very few statistics 20 years ago is because, I suppose, I mean, police officers, you'll know this, and it was alluded to, I think, in one of the overheads from either Andy or from Lucy, that the focus is on physical violence, because of course you're looking at the elements that the CPS and the courts, the elements of the crime. So physical violence is always going to be easier, some indication of physical violence. And I always used to say to my students, a pinprick to the thumb is going to be better. You know, I believe you've got to have this physical evidence. So we've got to change the way in which I think people, police, society actually see strangulation and suffocation. And as I say, more women are reporting it because they know that it's being taken seriously. I'll mention a bit later, the corroborative signs of injury are going to be problematic for police and CPS. But there we go. Person commits an offence if he intentionally strangles another person. So if you grab somebody, if the man or the woman grabs the other party by the neck, come back, or off the coat or the cardigan, the question is, and it strangles that person, was it intentional? And of course the argument will be, well, no, I hadn't got my hands around her neck, I was just trying to pull her back. There is a second route that you can go into this idea of non-fatal strangulation or suffocation, and that is, does any other act that affects ability to breathe and constitutes a battery. So I've been looking at quite a few cases, and police of you there, police will well know that the man pinned her down on the floor, with his knees. So, and did it affect her ability to breathe? Well, I should jolly well think it did, but that's the question. Pinning down in a particular way. Can we have the next slide, please? So just remember, it has to constitute a battery, which is our section 39. I'm sorry, there's a lot here. I'm just going to take one or two elements here. Of course, strangulation isn't defined. The explanatory notes, which are sometimes useful, state that it's not limited to suffocation or strangulation. So it could be choking. Intentionally strangles, well, I've mentioned a little bit about what that intention will need to be seen as. Then going down onto the slide, thank you, down to evidence there. This is important for police, of course. You've got to listen to what she says. You've got to ask her the question. You've got to ask her the question. And of course, Lucy talked about dash, this 27 questions, answers on the dash. So what's the evidence? What she says? Is she going to talk about it? What's the corroborative evidence? Oh, well, there isn't any. There's no marks on her neck. She's tearful, but she said she couldn't breathe. Is the physical injury? Is she frightened? All those factors that actually Lucy and Andy have talked about in a different way. So, of course, one could go down the route of charging with control and coercion if you considered that those elements that I've mentioned would be difficult to prove. And I've got a couple of cases there. You could look at the case of Power. Apologist for the word, but that's his name. Power, 2018. Sustained an attack, put his arms over her face so she could not breathe. Actually, it was seen as a section 18 and 7 years was upheld. Again, I'm repeating myself a bit here, but what to charge? Again, depending on the degree of injury. So somebody is strangled, non-fatal strangulation, and there is a bruising to the hyoid cartilage, there's a bruising to the neck, she couldn't breathe, she spent time in hospital, etc., etc. Are we looking at non-fatal strangulation with a sentence of 5 years? Or are we looking at a degree of injury which should be otherwise seen as a section 20 or even a section 18? A little bit on sentencing, but I want to move through a bit now because of the time. But sentencing now is taking all this on board. I'm not sure that that's of great value at the moment to police in terms of sentencing. Prosecutors, yes. So should we go on to the next slide, please? I think I've covered a bit of this intentionally or recklessly, but let's just underscore that. So strangulation must be intentionally strangled. So obviously if there's a ligature, if there's hands around the neck, if there's a headlock, I'm not going to talk about police and headlocks, you can deal with that in another, but it is relevant to you as well. So intentionally strangle is what is the mens rea there, or reckless. The precise ambit of what's required to prove an offence under the other act, which I mentioned, which could be pinning the person down, sitting on the person's chest, putting hands behind back, all kinds of different kinds of restraint, which could impede breathing. Again, it all depends on the seriousness of it, whether the NFS is going to be helpful for you. So can we move on to the next slide? It looks like I've covered some of this, so perhaps I've repeated the slide. Let's just see if there's anything else there. No, there's the Power case, what to charge, impedes breathing. Can we move on to the next slide, please? So defence of consent, with all this discussion, you'll be surprised, I'm sure, that, or perhaps not, that there is a defence of consent. But that's under 75A of the Serious Crime Act, which the non-fatal strangulation is part of now. It's a defence to show that the victim consented to the strangulation, but only if there's no serious harm. So it doesn't apply if there's serious harm, and serious harm is your 47, 20, what have I missed out? 18, that's it. So we're looking at section 39. So I'm not sure how that's going to play out in the court. But probably you're more interested in the corroborative signs of injury. Can we go on to the next slide? Again, there's a bit of sentencing here. It may be of interest to you, but certainly in terms of charging, I think, you know, if you're looking at a person guilty under this section, summary offence is 12 months now. As I said before, 5 years. So it would depend on the seriousness of the strangulation. I've put a few cases down at the bottom. You might want to note Allen 2020. How are the judges, if it's left to the court to cognize the meaning of non-fatal strangulation? Have a look at these cases, Allen and Loymes. You might note that Allen preceded the act, but it was an important factor in sentencing in that case. Then if we can move on to the next slide, please, Hannah. So the rough sex defence, I've already said there's a bit of overlap here. And as many of you will know, what section 71 of the Domestic Abuse Act actually has done has to put in statute that R.B. Brown case. You might be familiar with the case of a number of homosexual men who had inflicted injury on each other, and they were charged, and I forget the conviction, some of you will remember, you put it in the chat. I think they were convicted of 20? Yes, I've written about it. It was a long time ago, but the court said that there's no defence, if you like, to a sadomasochistic libido. What this has done is put it in the act, and of course the concern has been really with heterosexual relationships and largely men pleading rough sex defence, both in cases where women die and so the dead cannot speak in their defence, and in cases where women survive. But, you know, I'm talking in this binaristic terms, and I realise that we need to rethink the way we're talking. So it can include men and it can include they, and I want to stress that. But we're looking at the past law. So that's the section there. Let's go on to the next slide, Hannah. And Martin, if I'm going over my time, you can ping me or say something. I want to just mention—
You're okay, Susan, don't worry, we're all good.
It's all right, still all right. We've still got—
yes, still fine.
90 participants keeping in there with it. Okay, so I just want to mention the cases that moved reform. That's the picture of John Broadhurst. Now, you will all know that case, and I just want to sort of flag up, certainly in that case, the question of causation, what caused death, was problematic. We've used that again. It sort of covers everything, doesn't it? So at the end of that, Broadhurst was charged with gross negligence manslaughter. There was an absolute outcry, not only because of what he was charged with, and he served 22 months of a 3-year and 8-month sentence, but also because of the way in which he pleaded, if you like, rough sex, that she had consented to much of these appalling injuries. And you remember she was left bleeding to death at the bottom of the stairs while he went upstairs, went to sleep. I mean, that came evidence was the result of the telephone. Sorry, old person here. The mobile going up and down the stairs, right? So one could know what time he went up the stairs to sleep and so on. As I say, there were problems of proof, but it caused an absolute outcry. And the Member of Parliament for Natalie Connolly took up this case, and he uses the language, I can't claim it for myself, but he talks about traducing the character of the dead. And this is an issue I'm going to come around to at the end. And as I say, perhaps not immediate of interest to police, but it's important to be aware of where these cases can go. The other case, of course, was Kempson, and that was the Tinder date where Grace Mullane went out one evening, so it was just the one night, with this man who strangled her and claimed that she had consented to rough sex. So part of this, this kind of feeling that this is being used by men who kill as an excuse. And of course, some of you who might be older listening, you know, will know that we've shifted in the narrative from, oh, you know, she asked for it, she provoked. We've shifted some of the narrative now to saying that she consented to death. And, you know, I'd love to talk about the 19th century because there's some criminologists there, but, you know, 19th century writers, Havelock Ellis and Ivan Bloch, all these people who talked in the 19th century, you know, the Ripper time, talked about sexual psychopathy and would have said that any claim that some of this behavior was actually normal was then seen as pathological. We've kind of normalized some of this. Right, so let's go on to the next section 71. What does it say? Inflicts serious harm on person, the victim. It's not a defense to the infliction of serious harm for the purpose of obtaining sexual gratification. Remember, the non-fatal strangulation says there's no defense to serious harm. Relevant offence, that's the serious offence, same as the other section, 1820-47. Serious harm means what it meant for the other: grievous bodily harm, wounding, actual bodily harm. So can we move on to the next slide? Now, you don't have to agree with me on this, but you know, you might want to look in the papers, because it's not reported, of this case of Andy Anokie. He was actually sentenced to 32 years, and there was multiple rapes, multiple victims, false imprisonment. Thank you, Hannah, you're trying to go through all that. And some quite horrendous detail. He waterboarded the victims, told them they'd be shot, put another's hand in the water and brought an electric toaster nearby, threatened her with electrocution, and said, these are all my rape games. And I think this is what we're seeing now as a defense in some cases, that it was just sex play, rape games. And he went actually on to say, it's just part of the sex I have. Some of the best sex we've ever had was when I was raping you. So this rough sex creeping narrative, well, obviously the jury didn't take any of that on board. But have a look at that in the papers. I knew, okay, we got the date there, yes, somewhere. Sadistic rapper, solo 45, on trial for 22 rape charges. So moving on, still with the rough sex, I'm going to try and come to conclude this. You've been so generous listening to this. So if we can move on to the next. This is seen to be something that is something of recent origin, but I have managed to find cases which were much earlier, one in 1962, Shampal Singh, and then a case in Tasmania, went to the High Court of Australia, Bowie versus the Queen. You might want to look at those. So the idea that it is something that's just happening, although of course this narrative, I would argue, is more redolent in a society or a culture or a context where violent pornography and the treatment of women is more prevalent, which I would say is now than was then. So just moving on to the next slide. I mentioned a little bit earlier the problem with gross negligence manslaughter, and you might be familiar with the two cases of last year. This was just after the Act had dried on the statute book. It was about April the 29th, I think, 2021. However, of course, these persons had committed their crimes prior to the Act. And we had the case of Warren Coulton, not reported, convicted of gross negligence manslaughter. He claimed to have engaged in consensual rough sex with the deceased, who died of asphyxiation following being gouged with a sock in her mouth. He got 5 years for that. Then there was the case of Pybus. Now, Pybus was convicted of unlawful manslaughter. So in that case, as part of his defence, he said that the deceased consented to being choked. He got 4 years and 8 months, following credit for the guilty plea. The Attorney General, it was, anyway, whoever it was at the time, I lose track, they keep changing, don't they? I want to say Harriet Harman, but you know, anyway, appealed, I think it was Harriet Harman who asked the Attorney General, that was it, to appeal on the grounds the sentence was unduly lenient, and the Court of Appeal declined to increase the sentence. Anna, can we have the next slide, please? So coming up to summing up, remembering we're talking about risk, we're talking about harm. And we're talking about the fact that the defence of consent remains in cases of minor assault. So that's consent for grabbing, strangling, etc. Even where serious harm is caused, it remains open to the defence to argue a lack of intention or recklessness. In order to show that B consented, A will inevitably seek to adduce evidence of previous sexual behaviour. Now, although the legislation was supposed to stop this, if we've got a dead body, then the defendant has the right to rebut a charge of murder and say, well, look, it was an accident, he didn't mean to do it. So, of course, he will bring, and I have to say he, because there isn't any cases of she that I have found, he will, well, it might be they, but you get the point, it's not, definitely not she. So in this case, they will be able to argue that it was accident, that the victim consented, because there is a right there, isn't there, to be able to put forward a defence. And this is so in fact, this is what's happening. And the problem is, I know you police will be thinking now, what about the Section 41 Youth Justice and Criminal Evidence Act gateway? So if it's a rape, then there's that gateway, which says that you'd have to pass through one of the gateways to be able to adduce that kind of previous sexual behaviour character evidence. But if you're strangling somebody, although you may have a sexual motive, that gateway doesn't operate because it's seen as a crime of violence. So finally, has the DAA, those sections, can we move on to the next one? Thank you, Hannah. Has the Domestic Abuse Act achieved its intended aim in respect of these two sections here? And I think I've covered some of the problems, but I think what it does do is it puts the focus on non-fatal strangulation. It sees it as having a lethality potential. It depends on police and prosecutors, doesn't it? Who will ask the victim the question, because she may not, as we've seen, she may not regard that as serious. I think we saw that, didn't we? I noticed in one of the, I think in one of Lucy, one of your cases. But so it's really up to police training to be able to get the very best evidence that they can from the victim. So we move on to the next slide, and that's it. And I think, you know, this is just summing up. How do we negotiate this? I give the point I've just made about sexual offences falling under 41, but under violence, if it's strangulation, non-fatal strangulation, that doesn't exist there. So I think we've got to do, we people like me have got to try and put pressure on government and campaigners to change that element. But just getting back to the victim, that's the last slide. In Walker, which is the last slide, Hannah, we've finished now, thank you everybody. The last slide in the case of Walker, 2021, she says, it doesn't matter, I am nothing. And so, you know, this, I'm just looking at the impact on the victim, because we've heard quite a bit about the competing narratives, the kind of survivor or victim narrative and what they will say, and the police narrative, which understandably is focused on the outcome in terms of prosecution and getting the evidence for that. But it is disturbing to see that women who have been victims of non-fatal strangulation and rough sex are saying, you know, I'm nothing. So I leave you with that, and thank you very much for sticking with the afternoon. I think it's come together very well.
Thank you so much, Susan. That was really interesting. And as somebody who does not have a law background, you've really explained some really complex issues very clearly. So thank you for that as well. Yes, as Martin is very rightly giving us a little bit of a clap. Thank you to all of our speakers. Really interesting stuff. I think that we've covered a lot of ground in terms of some of the key issues in terms of domestic abuse. So looking at risk, looking at the crime harm index as well. I think that's a very interesting perspective on where we can move things, and obviously looking at specific legislation. These are all really key things to be discussing as we move forward with how we can appropriately respond to domestic abuse across all levels. So I will open up to questions now. We do already have some, so I will start with those. Please feel free to start putting questions into the chat for Susan as well. And obviously, as we're speaking, feel free to start asking follow-up questions as we go along too. I hope we can make it through all of it, but you know, we'll see how the discussion unfolds. So I will start with questions which are directed at Lucy, but please, Susan, Andy, if you do have further comments, do also kind of come in and say what you'd like to say. So the first question or comment maybe really was about dash being refused, as part of kind of when somebody comes to an incident, etc. Now the comment here is that the communication skills of police officers really should be sufficient enough that they can get sufficient information to kind of do the dash themselves in a way. So I think this is more about, Lucy, if you'd like to start with your opinion on whether this is the case. Is that something which we should be looking into? So even if the victim survivor refuses dash, should there still be another way of actually completing it? What are your opinions on this?
Yeah, so from my research, it looks like at the moment they will still complete it, but they'll obviously complete it based on previous forms. And then as we've seen with that police quote, the problem is this isn't showing you what's happened in that incident. You know, they could have called because they've been very scared, whereas previously maybe a neighbour reported it and it was lower. You'd have no idea. I think with this, I do think officers do need better training to be able to work with them. I know some of the cases I was working with, they said that they would have a domestic abuse car, which would go round with them. And that would include somebody who's not an officer, but who's obviously from a domestic abuse like charity, who's been trained to be able to work with them. And I think they found that actually in those cases, they would get a lot more answers because the victim feels like they're not under so much pressure. They're engaging with someone who's not in a uniform. The other thing as well is in certain cases, so especially the high risk ones, they would have a follow-up the next day with an officer who, again, would turn up out of uniform, and they would be specifically trained to work with domestic abuse and understand these cases. And in those instances, officers were saying that they got a lot more out of victims because, they'd had this time to consider what would happen to them. It wasn't, as Andy was saying, immediate threat to them where they're, very vulnerable. They've had a little bit more time to slightly recover and prepare themselves for this conversation. So I do think that there should be more of a question of maybe follow-up. So, if you don't want to fill out the dash form now, we might be able to come back tomorrow, but we really need this in the next 24 hours or something like that. Giving maybe victims a different option to understand and accept the kind of vulnerability and difficulties they're dealing with, I think could be better. And obviously, as you said, better training, I think, amongst officers would hopefully mean that they would be able to have better communication with victims and that they would be able to have a more sort of understanding approach or be able to present the dash in a way that's important. I think that's something that came out of Andy's work as well, was the way that officers explain the dash to them. So maybe if they had a better method of explaining why they're carrying out the dash and why it's useful and what it's used for, then hopefully victims would be maybe more willing to engage in those instances.
Sorry, I forgot I muted myself. Andy or Susan, do you have any follow-up to that? Oh, Andy's got his hand up. Yeah, I haven't even
noticed. You want to go to Andy?
Yes.
Yeah, I agree. Often the communication could probably be a bit better. There are certain cases where I think victims will just refuse to engage with the risk identification. What I was going to add was my colleague Catherine Holt did a piece of analysis on a sample of risk assessments from one force and found that actually the ones that were marked as risk assessment refused had a lot more in common with the high risk cases. So I think it's an operationally useful piece of information, and it does indicate the abuse is being minimized, and then there may be coercion and control there that's causing people not to engage with it.
It's very interesting. Yes, Susan?
Yes, this deserves a long thought about answer, and I agree with both Lucy and with Adam, you're now Adam, Andy. just taking a sort of look back historically, you know, I'm reminded of the way in which the law dealt with victims who refused to give evidence. You know, the greatest minds, I think it was probably Lord Wilberforce, if the victim won't speak, the common law cannot force it upon her. And there was an attitude then that it was really totally left up to her. And the biggest change that happened within policing, but you're going to the granular and saying, well, this is what the problem is that was to say that this isn't a private matter, this is a public matter. And there's nothing else, you know, we can't do anything else but look at the case and take it forward. But of course, the issues that Lucy and Andy are talking about, you're Adam now, Andy are talking about relate to actually safety, the whole question of safety. And I think I'd like to have a lot more evidence. You mentioned that these cases are likely to be high risk. Yes, that there's an absolute fear that next time, you know, he might kill me. On the other hand, we have a duty to intervene in that escalating spiral of violence, which we know from research historically does go on to result in death. So I think we need to have a sort of workshop and sit down and look at what the evidence is, and at what point we might say, well, we have to go ahead with this. And then I think, Lucy, you talked about putting in some mechanisms for safety. So otherwise, you know, we're back to where we were before, and where judges said, when women felt that they could be put upon by the defendant, and they were told by the defendant's solicitor, if you write a letter to the judge and say how marvelous he is, and that's what was happening. I'm going back, you know, I've documented it. I've put it under the title, Wonderfully Forgiving Wives, and the judges would say, oh, she's such a wonderfully forgiving wife, and it would impact on sentencing. So this is the problem of putting women in a position to think that their protection depends on them, and of course the degree to which he can manipulate. But what do we do about risk? And I don't know, you know, I don't know what the quick answer is to that. There isn't one.
Thank you. Those are some really interesting answers, which I think are just making us think of more questions. But I think that's the whole point of an event like this. I'm going to combine a couple of these questions which kind of came in after the first one. And that's because a lot of this is kind of centered on training. So there was a question for Lucy, but then also for Andy. And I think some of this came out of what Susan was talking about in terms of, you know, how much police officers should know, shouldn't know, and sentencing, etc. So it's a twofold thing. The first question relating to training came in from the perspective of how can we actually get police officers to gain a deeper understanding of the nuances, I guess, of intimate partner violence, but also, you know, domestic abuse, whichever way you look at it. But also then the second question, which was originally meant for Andy, was, you know, what can the College of Policing more specifically do to actually ensure that we do have better training, especially at the front line, who are the people who come across these domestic abuse incidents as first responders most of the time. So maybe I'll start with Lucy, as the original question was for you, if you'd like to start, and then we can go to the other speakers as well.
Yes, I think that's a really important question, because obviously the main way that you would deal with these things where you're sending officers out is training, because obviously they don't know what they're going to, and you need to tell them what are the things to look out for. So actually quite a lot of officers that I spoke to, some of them were specifically domestic abuse trained officers, and they would have training every sort of week on lots of different things. And they found that incredibly helpful. And they would also have people who were victims who would come in and tell them what they'd experienced. And I think it's really that victim impact that's really helpful, because they were saying, you know, hearing from this person, oh, actually the physical abuse isn't the worst thing. You know, it's not actually about that. It's the fear of knowing when you might be abused, or it's knowing, you know, something bad's going to happen if you want to talk to your family. It's these kind of other impacts that they need to understand. And it seems to be these ones, as Andy has said as well, that, you know, these more sort of controlling, coercive ones, they don't really appreciate. So I think it's very important firstly, the officers will have that better experience of what victims are going through and why it's important. Because again, as Ali said with arguments, there's quite a lot of cases where officers will say, well, not really much going on in this case, or, unless they're locked in a room, there's nothing bad happening. So these kind of like, I guess, undermining and not understanding how something can happen, even if it appears low level. So it's that explaining to them that even these small events can be serious, and that what impact it can have on the victim and how that hurts them. So I think that's the really important thing. And yeah, I think just more research, trying to work out what's happening here and what we can do. I know someone had a question also about Mockton Smith's, her research as well. Yeah, so actually one of the officers I spoke to who does provide the training was saying that she used that, which I thought was fantastic. And actually she was saying about how, they complete the dash form and then afterwards it will be assessed by MASH. They will then review it and see whether it needs to be upgraded, downgraded. And there were quite a few cases where they'd actually been downgraded and, officers weren't sure why this had happened. And she explained that officers could then request for that to be changed. And one of the good things coming out of that was they were saying that they would use this, this Mockton Smith's like numbering system of how to see escalation. And they would go, oh, actually, this is on level 6 or something. They're using and applying that level to understand how it's escalated. And I think that's really fantastic. And we need to create more maybe regulator training or more sort of like guides on what the officers can look for that can then be explained to them. But maybe that's something the college policing could do. So I'll hand over to Andy.
The college has developed training on domestic abuse, which was done in conjunction with DA sector groups. And there is some evaluation to that. And it focuses very much on these issues around identifying, controlling coercive behaviour. There was some evidence of impact on understanding and attitudes and actually arrests for controlling and coercive behaviour. Although we can develop training, we can't mandate training to forces. So I think around half of forces have done the training. And then there's also an issue of, it is a big endeavour to train the whole of a first response workforce, and especially when there's then going to be turnover of staff, and how often do you refresh the training? And I guess you have to remember first response officers cover a lot of areas and they can't be specialists in all areas, but there is that training and it has been developed. And also under development now is an extra module to add to that training, which will focus specifically on investigating the controlling coercive behaviour offence. So pitch that investigators, which I think will be an immersive learning product.
Thank you. Yes, Susan, do you have something to add as well?
Again, casting my mind back and also to the present, some of what's been said already this afternoon is about sort of the operational outcome. And the operational outcome is often seen in terms of the CPS charge, court conviction. And I think, again, we can't get away from the fact that if a woman is reluctant or appears reluctant to give evidence, or reluctant to proceed with the prosecution, this may well have an impact on police. I'm not suggesting that anybody who is still listening to this, it will have an impact, but that's something else we need to look at, because we know that a lot of cases that do get to court will be withdrawn or not dealt with because the victim refuses to turn up and all of this, and it's very demoralizing for the police, who have spent a lot of time, Martin wants to come in here, preparing a case for this to be the outcome. But I think the police have got to carry on with doing this and accept that that's one of the consequences. When I did my policing research a long time ago, before the participants were born, I'm sure, the police were no criming. I saw the no crime up on one of those charts. It might have been Lucy. And actually the police were no criming in about 95% of domestic abuse cases, because the victim did not wish to give evidence and it just went nowhere. We've come a long way, and all of you sitting and listening, you've come a long way, but we've still got some of these matters that will not go away. She will always be frightened and terrified of this consequences. She will always be a reluctant witness. And it's a question of whether we give in to this. Certainly for the risk factor, we need to look at that, but we mustn't give in once we've got a case that we must just go to court with it and it'll have to be NFA'd or whatever else you do with it. Can I just tell you how important these statistics are? In 1984, when I did my research, I told you it was a long time ago, on domestic abuse, there were 1985, there were 384 cases of domestic violence, which is what it was called, recorded in the Metropolitan Police area. And what that meant is if the police were no criming, which is what they were doing, with the liquid white paper, if some of you know what that is, you'd sit with the man at Hounslow, Holloway, who'd record the cases, and then he'd get the liquid white paper out, because the 30 he dealt with or had been dealt with were not going to go forward to prosecution. So he'd wipe that out and put 1. That was the case. That was the number that went up to the Crime Stats Division of C3 of the Home Office at the time. And what it said, 384 cases. This is not anything for us to worry about. We don't have to give any money for shelters. Local authorities don't. So actually, although statistics are not necessarily absolutely spot on, it's important to carry on and prosecute these cases, mindful, and I don't know, of the risk. Otherwise, this feeds back into the ether.
If it's possible to add in, I was just going to say, I think also professional curiosity would be a really good way to try and focus on this. Obviously, as we've heard, officers are not responding to just domestic violence, there's other incidents as well. But I think developing this idea and maybe rewarding this idea of professional curiosity might give officers that extra level to think, well, why is this victim saying this? Or, oh, do I need to probe extra on what they're saying on these questions? And really to, as you said, gather more evidence, even if it's not going to go somewhere, having that evidence written down so it can be used in other ways. So really encouraging that professional curiosity, I think, would be helpful.
Can I just add, the college has also produced guidelines on risk and vulnerability and identifying it, which does cover those things as well. It covers communication and professional curiosity.
Wonderful, thank you. I think this discussion that you've just had, I think also highlights the current state that we're in when it comes to police education, police training, the role of academics and the role of these kinds of series as well, because there's loads and loads happening, and the communication isn't quite always there. Not everybody is always aware of all of these developments, so I think it's really highlighted that we're doing loads. Let's just hope that it all continues going the right way. There's one more question on the chat. For those participants who are still here, you can still submit your questions. So there was one more question, and it was originally for Andy, but this is again a question I'm sure that all of you have an opinion on. So it was specifically looking into the Cambridge harm index score, and the question was whether it should be amended in terms of DA stalking, etc. Because the backup here is that the score does actually impact on a lot of intervention strategies, so offender management, victim safeguarding, etc. So I will start with you, Andy, as it was originally for you, and then we can go to some other thoughts as well.
Yeah, I think there's things you could do potentially to adjust scores or upweight them, but the extent that then takes you away from the underlying principle of it, I don't know. But as I said in the conclusion, I think there's a lot of other data that potentially you could bring to bear to create some kind of index of harm. So yeah, I don't know whether that means tweaking the existing frameworks or actually trying to develop something a bit more holistic that is still some kind of scale.
Susan or Lucy, do you have any opinions on this? You don't have to.
I agree with you. I agree. I'm in agreement. Lucy.
Yeah, I think that's the thing really, isn't it? We don't know necessarily enough, I guess, about coercive control or how to measure it to be able to know how to weight it. But I think that's the idea, isn't it? Looking at and always constantly reviewing what we've got and how to improve the way that we measure and understand it.
I mean, actually, non-fatal strangulation would be a good example, and I don't know where that fits into the scales, whether it's been added yet, but certainly before there was a specific offence, most of those probably would have been recorded as an ABH level assault or lower, so not reflective of the harm, I would suggest.
Thank you. Right, I do not have any more questions on the chat. Martin, I don't know if you want to use any voice that you have left over to say anything or ask a question.
No, not really. From my perspective, I'd just like to say thank you so much, everybody, for coming along. I know you're all busy, so very much appreciated. I'm sorry I couldn't speak, and I'm really thankful to Katerina for being able to be here and be my voice.
Excellent. So yes, on behalf of me, thank you to all of the organizers. So of course it is a joint series. So thank you to Martin, Paul and Ben and Hannah as well. I think that this has been some fantastic presentations. I'm very glad that I could actually be a part of this. And our biggest thank you, understandably, goes to Lucy, Susan and Andy. I just think that the work you're doing is absolutely brilliant. Yes, Susan.
I'm raising my hand. Yes, just to say to those people that are still listening, if you've got any questions you want to direct to me, it's susan.edwards@buckingham.ac.uk. Please email me if you want to, and we can talk a little bit further. I'm sure Lucy and Andy will say the same, but you probably know their emails.
Wonderful, thank you. We do have a couple of thank yous, a few thank yous from our participants for a thought-provoking afternoon, which I would totally agree with. If anybody is interested in slides, then I'm sure you can email wherever you got your confirmation from about this event, and we can get in touch. You can also email the center at Christchurch, which is just ccpr@canterbury.ac.uk, and we can be in touch and we can facilitate giving you the handouts. So I think we're concluding. Yes, so thank you so much. Honestly, really enjoyed today. Thank you to all of the participants